Welcome to the Estate Blueprint, Planning Your Future with Tom Begley.
Welcome back to the Estate Blueprint, Planning Your Future with Tom Begley, where clarity meets compassion. Attorney Thomas D. Begley III is a certified elder law attorney with more than 35 years of experience helping families across New Jersey protect their assets and plan for the future. I'm LeAnn Lyon, and today we are breaking down the difference between revocable and irrevocable trusts and how each one actually works in real life in New Jersey. Hi, Tom. It's great to see you again.
Nice to see you again, LeAnn. So fire away.
Well, I'm actually really fascinated with this topic. But to begin for the audience, what is a trust and what role does it play in estate planning?
LeAnn, that's a great question. And it's really one that I think the public needs to know more about because I get countless people that come to my office and say, I need a trust. And they don't know why they need a trust or whether they really need a trust. It's just because some friend of theirs may have gone to some trust mill or to an attorney that just does nothing but trust, regardless of whether they're necessary. And they just, think, let's get this thing done. However, a trust is an agreement, and agreements come in all shapes and sizes. Unlike a will, for example, that really, two things, maybe three things happen. The will says, when I die, my assets are going to go to these people, and this person is going to get it. They're the executor, and if there's minors, who's going to take care of the young kids, and of course, sometimes a trustee for the kids. So it's a pretty finite, document. And a lot of times trusts are set up to be, for lack of a better term, a substitute for the wills. And that's a lot what the living trust will do. However, there's a reason to have those, and sometimes reasons not to have them. And likewise, in whether they're revocable or irrevocable depends on the sort of purpose that you need. So if you're really looking at solely for estate planning purposes and with some flexibility, a living trust is fine, especially if it is a revocable living trust because you can change it or amend it at any time. Most any other type of agreement that you have is going to be irrevocable because you're trying to get a purpose satisfied. For example, if you're an older individual who's concerned with long-term care costs, you may be looking at a type of trust to preserve assets from, from those costs where you have to deal with the Medicaid laws. And those trusts you can't change once you sign on the dotted line. Likewise, if you have a trust, for example, for a child who has a disability, um, it would be called a special needs trust. And those, once they're funded, have to be irrevocable. So, but trust agreements, as I said, they come in all shapes and sizes. The key question when you're deciding whether or not and what type of trust to get is, why am I getting the trust and what is the purpose that is being satisfied? What is the objective?
So I'm actually curious about one thing you said there, that there may be times not to get a trust, where I think a lot of the conversation out in the world is everybody should get a trust.
Well,
Everybody understands wills, but why not get a trust?
okay. Well, that goes with the issue of the living trust. New Jersey is a relatively unique state in that our probate requirements are extremely minimal. Uh, for example, most states do have some form of probate, and a lot of those states, the probate is time-consuming and expensive. For example, I have many clients who have real estate down in Florida, and when they pass away, their executor is able to handle their real estate in New Jersey plus all of their liquid assets, but real estate is governed by the state in which it's located, so they'll wind up having to do what's called an ancillary or second probate just to get rid of the Florida property after they've passed on. Their executor would have to do that. And down in Florida, whenever I've had to get anything moved as far as real estate, and I've the attorney down there, and it's pretty much the going rate has been about $5,000. That's just to get one piece of property moved, and they have to file a petition. New Jersey has the easiest probate state in the country, and I say that without exaggeration. Back, I believe around 2000, a group that I was involved with and still involved with, the National Academy of Elder Law Attorneys, did a bit of a survey as to the probate requirements in each state. It was pretty clear that New Jersey's was the easiest. So when somebody passes away in the state of New Jersey, the executor can go to the surrogate's court, which is the office in the county in which wills are probated in New Jersey. And all they have to do is bring the will, the death certificate, and the executor has to answer just really a couple questions as to the names and addresses of the beneficiaries under the will as well as the next of kin. The appointment takes all of about 20 minutes, 30 minutes tops, and voila, that's pretty much probate in New Jersey. Although many of my peers would probably be upset with me for saying this, I don't think you need to have an attorney go to the circuits court. I've told people the day I start charging someone $500 an hour to go to the circuits court and help somebody probate a will is the day I decide to burn in hell when I die. It's just that easy. Um, and because it's that easy, uh, you don't need to have a living trust to quote unquote avoid probate. I mean, there's really two other requirements that are for people that have wills and have to, for the executors. One is that within 60 days after will is admitted to probate, the executor has to notify, the next of kin as well as the beneficiaries under the will that the will has been filed for probate and that they're entitled to get a copy of it. And the only other thing that has to be done is what's called a release and refunding bond, which is a document which gets signed by the beneficiaries to conclude the administration of the estate, acknowledging the amount that they're going to receive from the executor on behalf of the estate. And that form basically is what I call the speak now or forever hold your peace document. I mean, its main purpose is to discharge the executor from any further obligation or liability to the estate and its beneficiaries. And frankly, in 36 years of practice, I've never seen any of the county offices enforce either of those two requirements. And even if you were to have a living trust, I would recommend people use for refunding bonds and releases. So many people here can get good quality estate planning. I'm talking about wills, advanced medical directives, powers of attorney, designations of funeral agents for $1,000 and change. Um, and to set up a living trust, oftentimes at least a few $1,000s. I can't look somebody in the eye and want to spend 3,000 rather than $1,000 if I'm not going to do anything that's going to benefit them. So if everybody has all of their real estate in New Jersey and all their liquid assets, of course, basically you don't need to have a living trust for the most part. So the big lies, the reason why people get them nevertheless, are what I call the living trust lies. One is um, that it takes years and it takes cost thousands of dollars. Well, as I just said, it can be done 10 days after death, and the filing fee is about $150 to $175. So that's lie number one. The second is that the executor gets paid 10%. Now, the statute, it's a decent commission, but it's 5% of the first 200,000, 3.5% of the next 800,000, and 2% of the balance, not 10%. My favorite one, of course, is that if you have a will, when you pass away, your executor has to use the attorney that prepared the will, and that the charge to administer his estate is $65,000. That seems to be like the common number when they're pressed about it. These trust mills and a little less scrupulous people that do these regularly. Uh, States still cost 65,000. If that was the case, I would work for 2 months at the beginning of the year and spend the rest of the year in Costa Rica. Really, it's it's if you do need help legally, it's typically if it's a relatively simple state, it's a matter of a few $1,000s. So people get living trusts because there's a misunderstanding that they need something when they don't. But that's why you go to competent counsel and honest counsel. They'll let you know whether or not you need it.
Wow, that's really fascinating because I do speak with estate attorneys really all over the nation. And I, in fact, sold living trusts way back where I gathered the information for an attorney. So hearing this, and things have changed over the years too. I'm part of Gen X, and is it estate planning was just different when I was out there working with families. Now it's changed quite a bit, and wow, I did no idea that New Jersey was that special.
Yeah, New Jersey, and I guess the next state is Pennsylvania. Pennsylvania, they have one additional requirement, and that's that you have to file an inventory 60 days. The executor has to file an inventory 60 days after they become appointed as the uh, get appointed by there. It's called the Register of Wills rather than the surrogate. Um, but outside of the New Jersey, most states are more like Florida and California. So when people are telling me that they live in other states and they get living trusts, typically a lot of those states, it is a good thing to do. We just happen to be, an exception.
So, when in New Jersey, owning only New Jersey property, would it make sense to get a revocable or irrevocable trust?
Excellent question. Kind of a sad answer that I will give you. There's two types of trust. One is I'll call the historical, estate planning trust. The ones I had mentioned before, which we could certainly get into a little later if we have time, and that's a special needs trust and the with what's called, in the various Medicaid planning trusts and what's other thing called a bloodline trust, which I'm a big fan of. But the real big time that I'm setting up living trusts nowadays is what's called an irrevocable living trust. Now, why would you do something irrevocable which you couldn't change? Unfortunately, as many of us are aware, elder abuse is becoming rampant. People are just shameless, and the instances of people ripping off their parents and doing other horrible things, it's not really bad. It's just the outside predators, the people that make phone calls. I get too many calls. I mean, it's not every day or every week, but enough of them that's disturbing that, a really nice person who was in the beginning stages of dementia was scammed out of hundreds of thousands of dollars on the phone. I've dealt with two cases alone in the past year on that. And two cases is two cases too many. So one thing I figured out some years ago was, and it was really odd. Well, I only had to do it like maybe once every year or so, but now I'm doing probably at least a dozen times a year, is we're taking the living trust, making it irrevocable, and what we do is we make the child who would be the backup trustee upon death, making them the trustee in life. So, for example, I had a case earlier this week where mom had three children. Mom went to John Doe attorney at law, whose qualifications to do estate planning didn't exceed, unfortunately, his desire just to cash the check. And he did what unfortunately many people do and said, just who do you want to have be your executor? So, of course, she chose the oldest. And that's where the problem started because the oldest has always been a train wreck financially, and certain things bad start happening with the money. Fortunately, hadn't gotten too far, but the daughter, who was the youngest, who happens to be very responsible with money, reached out to me through a friend, and we were able to transfer all of mom's assets with the exception of a checking account because mom's in her mid 80s and has some decent health issues. And what happens now is usually with a revocable living trust, the person who sets it up is also their own trustee because you want to treat your own money like it's yours while you're alive and healthy. But in this case, the good daughter will call her. She's the trustee immediately. So if somebody tries to call mom from the outside to scam her on the phone, or if one of the siblings tries to get some money, they have to go through the healthy daughter who's going to pump the brakes immediately and make sure the money doesn't get stolen. And the next thing, because this does arise, if somebody's unhappy, they will sometimes try to trot mom down to another law office and see if they can undo the trust. Well, because it's irrevocable, it's set in stone. It is kind of funny. I've actually seen some people walk out of offices where they'll have an amendment to the trust, but it's not effective because you can't, change or revoke that. So this has really been a great safeguard for the elderly. It's very sad that we have to do something like this. However, in this day and age, I think if you happen to see, mom or dad or your spouse slowing down and maybe having some cognitive issues, it's in the category of better safe than sorry to set one of these things up. It's probably one of the most valuable things I can tell you this morning.
Well, as we're kind of coming to the close of the episode, let's explore how do revocable and irrevocable trusts differ when it comes to things like taxes, asset protection, and Medicaid planning.
As far as the revocable living trust, really, it avoids probate and it's a private document, which sometimes actually is the reason to do it, even if you don't have real estate outside of New Jersey. I should have mentioned that earlier. But from a tax standpoint, whether it's revocable, irrevocable, there should be virtually none or if any tax difference. However, the huge difference is twofold. One, the irrevocable trust, once somebody signs on the dotted line, that's it. And it's nice to know that if somebody is motivated to have an objective, such as preserving their assets from potential predators or long term care costs, or on behalf of children that may need some protection from, uh, from in the category of special needs or spendthrifts, that's available. But so that's the one thing is just the protection that it provides, and the second, as far as the Medicaid issue, uh, in order to get anyone to maintain their eligibility for public benefits, the trust needs to be irrevocable. So a lot of the planning trusts involve 5-year look back, with the exception of the special needs trust. But the idea is that they're revocable. The state can come around and say, well, revoke it and pay the money for the care or just replace the benefits. So it has to be irrevocable for it to work. And the other one, which I'll put in, is what's called the Bloodline Trust. That needs to be irrevocable as well, because really the two big trusts I'm focusing on these days are the Irrevocable Living Trust to protect people from predators, and the other big one is this one called the Bloodline Trust. And I call that the insurance for the inheritance. So mom and dad pass away, rather than leaving their assets outright to their children, for example, they can leave it into a trust for the benefit of their children, and the child is each child, so long as they're responsible financially, they can be the trustee of their own trusts. So it's one of the rare occasions in the law where you can have your cake and eat it too. And those trusts have been valuable because we have a 50% divorce rate. So if the daughter is married to someone who winds up divorcing her, that's not going to be considered for property distribution. It's not going to be considered for child support or alimony calculations, because the reason is that children don't have a right to an inheritance. So mom and dad can leave behind a trust with strings attached, and these are enforced throughout all the states. If someone has a creditor issue and they get a judgment against them, well, they can't touch the trust because it's the children have the right to use the money, but they don't own the money. And the one thing I really, really like a lot is that it stays in the family. So even if you have the nicest son-in-law, the nicest daughter-in-law in the world, if you got grandchildren, nobody's more important than they are. And I can tell you this from having 3 granddaughters of my own. And so the nice thing about the Bloodline Trust is that, unlike a customary distribution where if you leave everything to your kids, when they die, it'll go to their husband or wife. The nice thing is that you can leave it to your children, and when they die, it goes to the grandkids. They don't have grandkids, it just goes to the other kids. So it keeps it in the bloodline or the family.
Well, as we wrap up, what should someone understand before deciding whether a revocable or irrevocable trust fits their situation?
Yeah, this the risk of making the proverbial shameless plug for the legal profession. This is really, and as I indicated earlier, I mean, there are things you don't need to have an attorney for, like going to probate. So I don't say these things very often, but because of the nature of trust, and as we've kind of gone over this past segment, how different they are, in the purposes they satisfy, the misperceptions. I tell people that the best thing that I give clients is not so much the written documents, but the advice. So before you make a decision, you want to speak with somebody who's competent and honest in this area, who will look in the eye and tell you whether or not you need something. They said I could make a lot more money if I was going to tell people to, just get a living trust. So many people come to my office just hell bent on getting them, and they don't mind dropping a few $1,000s. But you want somebody that's able to be honest enough to walk away from the money. So the biggest thing to answer your question is, before you make a decision, talk to a competent professional, whether it be an attorney or accountant or qualified financial planner. But really, since this is a legal thing, it should be an attorney, to determine A, if you need a trust, and B, what sort of trust you need.
Perfect. Well, that is it for today's episode of The Estate Blueprint, Planning Your Future with Tom Begley. If you'd like to learn more about how Tom Begley and his team can help you choose the right planning tools for your situation, visit Begley3law.com. Thanks for listening, and remember to like, leave a review, and subscribe to the show so you will catch the next episode. Thank you, Tom.
Thank you, LeAnn. Have a great one.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.